everyone.
Hello.
Nice to see all of you in the room. Nice to see all of you online. I am Jessica Summers. I am one of the co-chairs of Lurch Early's Employment Law Group. We are thrilled to have all of you here today. We have some fantastic speakers in our group and some fantastic topics to cover. So just a few housekeeping items before we kick off today. The presentations are being recorded. The slides will be available, as well as the video recordings of the presentation. So if you miss anything, don't worry, you can watch us again, or if you have insomnia, you can watch us again tonight. If you have any questions, please feel free to raise your hand in the room, or for those of you online, put them in the chat. We aren't going to have a extended designated question time, so for those of you online, feel free to reach out to us by email or chat. For those of you in the room, that is part of the purpose of our networking reception afterwards, so that we can do some one-on-one question and answer time. And again, for those of you in the room, we are going to be having networking, appetizers, and drinks after, so please stay if you have the opportunity to do so, to chat with us. We will not be taking extended breaks as we go throughout. We'll be doing short breaks, switching through presentations. So for those of you in the room, restrooms are just outside, and please feel free to step out whenever you need to, but we won't be doing extended break. So with that, I will pass it off to our first presenter, Julie.
Nope. I'm not using that.
I don't think that was ever actually on.
Oh. Hopefully I'm mic'd and working. Yeah. Okay. All right. Good afternoon, everyone. It is a pleasure to be kicking things off with our Employment Law Day 2025 with a discussion on accommodations. There's the slides. So this accommodations is a topic that I find incredibly interesting. It might be one of my favorite ways to assist clients. I find them very interesting because they are so fact specific, right? An employer can't take a blanket approach to an employee's request for accommodation. It has to go through a reasoned analysis using a legal framework with the goal of hopefully, in the end, finding a positive solution that works for both the employer and the employee. But given that there's no bright line rule to apply to these situations, how does an employer know how to handle it? How can it be prepared to handle that next request for accommodation that comes up in a legally compliant way? And I think there's two parts to this. First, you need to ensure that you understand the legal framework, right, that applies to that situation. And then second, you need to understand how fact finders, such as the EEOC, the Equal Employment Opportunity Commission, and the courts have handled similar situations to the ones that is before you. So I'm going to spend the next 20 minutes or so talking with you about recent changes in the law of accommodations. And then we're going to go through some accommodation analyses applied by the EEOC and the courts. So there we go. There we go. So I'm going to start first in the area of religious accommodations. And that's an area where we've seen a major change in the law and also an increased number of claims. So starting first with the law. 2 years ago, the Supreme Court issued a decision that changed one of the key elements for analyzing requests for religious accommodation. And the case was Groff versus DeJoy. And in that 2023 Supreme Court case, the court held that an employer's duty to provide a religious accommodation is not determined by whether the accommodation would have had more than a de minimis impact on the employer's business. That de minimis standard is the rule that we had been applying for many, many years. Instead, the court said, no, the test for undue hardship is whether the accommodation would cause substantial increased costs in relation to the conduct of the employer's particular business. Now, the Supreme Court didn't provide much guidance on this due standard, and so now we're seeing trial courts, federal district courts, and some federal appellate courts at the lower levels interpreting the standard. And they're doing this in an environment that has increased public dialogue on religion and also the intersection between religion and the workplace. So Gone are the days where you might have, once every other year, a request for religious accommodation, and it was, simply for a change, request for a change to schedule based on a religious holiday, or a request for space and break time to pray. I mean, we were having, I think, even as employment lawyers, we were having maybe once a year-ish type, requests for accommodation assistance or claims that were coming to us. Now we're seeing much, much more in terms of requests for religious accommodation, and they're different, right? They are things that are not easily quantifiable, not easily applied to that substantial increased cost. So things like people requesting exemption from anti-harassment training, right? Because they feel that the content goes against their religious convictions, or requests not to use a colleague's preferred pronouns, or not use a colleague's preferred name for transgender colleagues, or requests not to have the COVID vaccine, right? If that's a mandatory requirement for that workplace. These things are not easily quantifiable, and it makes that substantial increased cost standard much more difficult to apply. So I think the best way, again, for us to figure out, how would that apply? What does that look like? What is substantial increased cost? Is to be looking at how the EEOC and the courts are interpreting it. And I'll start with the EEOC because they are really leading the charge on defining what substantial increased cost is. In the first 200 days of the Trump administration, EEOC's acting chair, Andrea Lucas, said that she was restoring even-handedness enforcement of Title VII, ensuring that workers are not forced to choose between their paycheck and their faith. She noted robust EEOC enforcement action taking place in the areas of vaccine mandates, accommodation requests for schedule changes, break time for prayers, and adjustments to dress code, all reflecting the agency's strong ongoing commitment to upholding religious liberty protections for their workers. In addition, she noted the EEOC is also engaged in combating anti-Semitism in universities and on college campuses, and creating a task force to eradicate anti-Christian bias in the federal government. Specifically, the EEOC has recovered over $55 million for workers impacted by vaccine mandates in violation of the ADA and Title VII, including a $1 million settlement that they reached with Mercy Health due to Mercy Health's failure to provide religious accommodations for vaccine requirements amongst its employees. Instead, Mercy Health had been terminating and demoting employees who refused to be vaccinated. In addition, the EEOC has filed suit against many private employers on religious grounds. They sued Rock Snow Park for firing an employee for faith-based social media posts, specifically Bible verses, that the person was making on their personal social media account. The EEOC sued Cemex Construction after the company failed to accommodate a truck driver's request to wear a skirt over pants in accordance with their Christian faith. The EEOC reached a $47,500 settlement with Buffalo Wild Wings in response to a claim that was filed by an applicant who alleged she wasn't hired because of her Pentecostal Christian beliefs, which included wearing ankle-length or below-the-knee-length skirts. And the EEOC secured a $61,000 settlement with a North Carolina dental clinic who had fired an employee over her request to wear a scrub skirt for religious reasons. And perhaps the biggest settlement that the EEOC has reached this year is the one that was reached with Columbia University for $21 million based on the university's alleged civil rights violations against its employees, including a specific complaint that had been brought by the acting chair on behalf of a class of all Jewish employees alleging harassment based on national origin, religion, and race in violation of Title VII. So you can see the EEOC is very, very active in this space. And for most of us, in most situations, the EEOC is going to be the first adjudicator of any claim that you're going to see. So it's very important that we understand what the EEOC's position is so that we can help analyze how best to proceed in various areas of religious accommodation. In addition to the EEOC, the courts are also starting to give an indication how they're going to interpret the Groff standard. Scott, can you? Yeah, thank you. So the first area that we're seeing is that, if we didn't know it already, the new undue hardship standard of substantial increased costs is much, much higher than what the de minimis standard was. We are seeing appellate courts generally in the post-Groff era reversing summary judgments that have been entered in at the trial courts in favor of employers and sending cases back to be re-adjudicated, in some instances retried before juries based on their failure to meet, the employer's failure to meet that higher standard of substantial increased costs. And I think the best way to learn about these cases is to kind of go through the facts because you can see how they might apply in situations in your workplace. So the first case I want to talk about is a Third Circuit decision in Smith versus Atlantic City. And in that case, Smith was a long-serving firefighter for the city of Atlantic City. And specifically at this point, Smith was serving as the only assigned air mask technician. And Mr. Smith had a beard. And the policy of the Atlantic City Fire Department was, under their grooming policy, no beards allowed. And he said, you know, based on my sincerely held religious belief, I would like the ability to grow a beard. And the city said, no, that's not allowed. We have this grooming policy for safety concerns. Specifically, we need to make sure that the breathing apparatus that you use as a firefighter, right, the seal is complete, right? That there wouldn't be any leakage in there so that you're safe. The city refused to engage in the interactive process and instead issued a blanket denial. Nope, you're not allowed to do that. However, the court dug into the facts a bit and, based on what Mr. Smith argued, said, look, it looks like that Mr. Smith's job was to maintain the breathing apparatuses. And even though he was supposed to have a certification that he was, you know, to know how to use them, he actually, as part of his job, he wasn't using them. He wasn't required to go in to burning buildings with that breathing apparatus on. In addition, the court said, an employer, you have some exceptions to this policy that you're applying on a regular basis. In addition, I think what really bothered the Third Circuit in this case, the fact that the city failed to explore any alternatives to the request and the denial. The court said you didn't try to fit test and see if that beard actually interfered with the seal. You didn't continue to exclude him from these job requirements, you know, running into burning buildings, putting him in a position where he wouldn't have to do that. You didn't need, you know, you've been doing this for years. Why all of a sudden now is it a problem to have one person who gets this accommodation? Accordingly, the court said the city had not sufficiently demonstrated substantial increased costs associated with granting this accommodation. Specifically, it said the city needed to show that the burden rose to the level of being unjustifiable or excessive. And essentially, the court said, you haven't done that. And so they remanded the case back to the trial court. So big takeaway from this case, of course, no blanket no's, right? You know, when an employee comes to you with a request for accommodation, maybe you get to no, but it's a no because this, and it's going to be expected because you've gone through an interactive process, engaged with that employee on what the concerns are, how the what the employee is requesting interacts with their job duties, and see if there's another way that you can accommodate. Another example from the Fifth Circuit, the case of Hebrew versus Texas Department of Criminal Justice, also concerns a request for exemption from a grooming rule on religious accommodation grounds. In that case, it was a corrections officer that requested exemption from the grooming policy because he wanted to have long hair and a long beard based on his sincerely held religious beliefs. And the correctional facility said, no, that's an undue hardship because every time this person comes to work, we have to search them for contraband. And if we have to search through long hair or a long beard, that's going to add additional time to that process that we already, you know, delays the beginning of each day. In addition, they said, and there's safety risks. Sometimes these correctional officers are involved in fights And if they have long hair, long beards, the inmates could be using those and grab them as part of a fight. And they also said sometimes correctional officers have to wear gas masks and this would interfere. And the Fifth Circuit said, well, that might have been enough to meet the de minimis standard, but that's not the standard that we have now. Again, substantial increased costs. A few minutes extra for a search through long hair is not substantial. And then the court said, and again, you had some exceptions to this policy. You allowed female officers to have long hair, and you allowed other officers to have short beards. So the safety risks weren't really an undue hardship, again, to have this one additional officer with this different standard of grooming. So the takeaway again here is what was once de minimis does not equal substantial increased costs, right? We need to really dig in and show the impact that the accommodation would have on the employer's business. Now, those substantial increased costs don't have to be financial. After Groff, we were very concerned that is the Supreme Court really saying that we're just looking at dollars and cents, or can we be looking at non-economic impacts as well? And we've seen some good appellate court, comments, if not holdings, that non-economic costs are still things that we can consider. In the Smith versus Atlantic City case, the court said we still can evaluate economic and non-economic costs as a source of undue hardship. And then there was recently an opinion by the Seventh Circuit in the case of Cluj versus Brownsburg Community School Corporation that held that objective non-economic disruptions to an employer's business can create undue hardship sufficient to deny a religious accommodation request. So far, non-economic costs like safety concerns, efficiency, productivity, all can be considered by the employer when determining whether or not there's been an undue hardship. So I want to talk a little bit about the Cluj case, because I think that the facts of that one are something that we might end up seeing more and more of in the workplace. And that is religious accommodation requests pertaining to the treatment of transgendered individuals in the workplace. So in the Cluj case, the plaintiff was a high school orchestra teacher who refused to address transgender students by their preferred name and pronouns based on his Christian beliefs. He said, I believe that sex is binary, it's unchangeable, and it would be a sin to address a transgender student in a way inconsistent with their biological sex. The school had adopted a policy that required teachers to address transgender students by the names that the student and their parents had submitted to an online database. And so this teacher said, look, I can't comply with this policy, but I have an idea. How about I call the students by their last name, the same way that the coach, on the football team or the baseball team is saying, using last names to refer to students. Is that, a permissible way to handle this situation as an accommodation? And the school agreed, and they agreed for 1 year. But then after a year, they rescinded their position and the accommodation because they started receiving complaints from the trans students, parents, and trans faculty saying that this made them feel uncomfortable. Specifically, there was evidence that this teacher was continuing to address cis students by their first names, was using sex-specific honorifics like Miss and Mr. With these other students. And there was evidence that he was not engaging at the same level with transgender students. So the school district said, no, we can't continue to provide this accommodation to you. You have to follow the policy. You're making people feel uncomfortable. The teacher resigned and sued, claiming failure to accommodate and retaliation. So this case wound its way through the court system before Groff. Actually went the whole way up to the appellate court in the Seventh Circuit, and then ended up in a place where it was back before the Seventh Circuit in a post-Groff analysis. So just the beginning of August, we received the court's opinion under the post-Groff analysis. And unsurprisingly, the court said the employer had failed to demonstrate undue hardship. Specifically, They said that the school's claim that the accommodation interfered with the school's mission to foster a safe, inclusive learning environment for all students was insufficient to demonstrate undue hardship because they only had a few complaints, the court said. Again, the standard is excessive, unjustifiable hardship. And the court said a few complaints from a few individuals does not meet that standard. And in support, the court quoted something that is included by the EEOC in its operations manual, and that's undue hardship requires more than proof that some coworkers complained or are offended by an unpopular religious belief. In addition, the school argued, look, we're going to have Title IX liability because we're going to have, potentially people are going to feel that we're treating transgender students differently than other students. And the court said, that's speculative. Look, if you would have just gone along with the last name approach, you'd be treating everybody the same way. And we don't think that there's going to be liability under Title IX. There's nothing that's been adjudicated supporting that. So case is going back. But if we've learned anything from the courts at this point is that standard of undue hardship is much, 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 much higher than the de minimis standard that we were faced with previously. So what are some key takeaways for employers? First, of course, you need to be taking these religious accommodation requests much more seriously than perhaps you had done under the de minimis standard. A couple things to do in preparation for that. Review your job descriptions and your job postings to ensure that they specifically define what the job requires and in terms of duties and the days and hours when the work needs to be performed. Because if you don't define in that job description or that job posting, specifically what it is that the person is supposed to be doing or when they're supposed to be doing it, you're going to be left to an argument by the employee as to what that is, right? There's going to be evidence submitted by both parties, and the employee will be able to argue, well, this isn't an essential function. And so essentially you could be ending up with like a call center employee who through a religious accommodation request, wants to work at times that the call center isn't open if you haven't clearly defined that in your job descriptions and your job postings. Second, engage in the interactive process, right? There is no blanket no that should be in response to any request for accommodation at this point. Make sure that you're actively engaging with employees. Make sure you're listening to the employee, right? Hear what they have to say on the topic. Explore reasonable alternatives. This is a two-party process. The employer can suggest alternatives and talk with the employee and see if that will work. If you think you have undue hardship, definitely go through that. Make sure that if you have an accommodation request that doesn't propose that substantial increased cost, that you grant it. But if you do end up going through that analysis, you want to be looking at what those costs are in terms of the impact on your coworkers. Does this create some kind of disproportional impact on this person's colleagues, right? If they're all not working that shift because of a religious accommodation, or they're not engaging in that type of work due to a religious accommodation, can the company still, the employer still fulfill the function that it's required to do? Can the employer still carry out its business if they have this person not engaging in that job duty? Is there an infringement on any kind of safety or security? But of course, as we saw from the cases, right, make sure that there aren't all kinds of exceptions, right? And that you're simply just not applying it in this situation. And if you're dealing with conduct that could be viewed as proselytizing or coercive religious conduct, my recommendation is you don't want to be focusing on morale, because that's really hard to demonstrate, what is a substantial increased cost on morale. A better way to look at this might be from the standpoint of retention and recruitment, right? People don't like to be in working environments where they feel like they can't contribute, where they feel like they can't be successful. And so if you're able to demonstrate that through, what the cost of additional recruiting and retention or the impact on retention to employees, that's something that could perhaps reach that substantial increased cost standard. And then finally, maintain records of the requests, of the rationale, that and how you got to the decision that you did. As we saw in some of these cases, it takes a while for these cases to eventually go before the EEOC or the courts, right? Sometimes the employees just, going through a process and they file, months later. So that's something that you want to be thinking about, making sure that you document it at the time so that you have a record. Okay, I'm going to transition now to disability accommodations. Now, disability accommodations is not an area where we've seen big changes in the law. We haven't had an equivalent Groff type decision in disability accommodations. But what we have seen is major changes with regard to the work environment. Specifically in our post-pandemic world, right? We have a situation where lots of employees were working remotely and want to continue working remotely, and they're looking for all kinds of ways to, allow themselves to continue doing that. So we are seeing more and more disabled individuals who are able to do their job in a remote work environment, requesting remote work because they don't want to expose themselves to the workplace. Perhaps they're immunocompromised due to a condition, right? And they feel like being in the workplace will expose them in ways that is harmful to their health. Seeing a number of requests in that way. Or perhaps they have a mental health condition that they feel could be negatively impacted by having to be in the work environment and performing the job duties in person. So there was a recent decision here in DC on this topic that I think is illustrative that I just want to go through. And that's the case of Smith versus District of Columbia. And this was a case where we had Smith was a deputy court clerk working in the Superior Court of the District of Columbia, who was recovering from breast cancer. During the pandemic, she was working remotely, as most in-court employees were. And then in 2022, the court began to bring employees back to in-person work, and she continued to work remotely on a full-time basis. But then the courts started to see more foot traffic coming into the courthouse. They had this huge backlog of cases. And so they said, we can't continue to accommodate this. We need our clerks to be here in person doing this work. And so the employees started participating in their in-person work requirements. Initially, the court was bringing clerks back on a 1 week in-person, 1 week remote basis. And so she began going through that rotation, but that at some point she said, no, this is harmful to my health. I can't continue to do this. I need accommodation, working 100% remotely on the basis of disability. Again, being exposed to potential harm in the workplace due to my condition. The court said no, and so she resigned and filed suit. And in this court case, interestingly, that the court said, look, there's just things that a clerk needs to do in person. They have to actually stamp documents in the District of Columbia. They have to assist customers, people that are coming to the clerk's office in person. They have to do an administrative file review that is, actually in person, or hard copy files and things that are only available on site. And they have to administer oaths. And the employee said, yes, I acknowledge there are some things that, can't be done on a remote basis, but I've been getting great evaluations. Like my performance metrics are all showing that while I'm working remotely, I'm doing a great job. I've excelled in my job. And the court said, that does look like she is able to perform the essential functions remotely. And they said, based on evidence that, the employee provided, clerks often didn't have a lot to do when they were on site. And they were able to use this 1 week on, 1 week off system effectively. And so the court said, look, I think there's enough here that it's up to a jury to decide whether or not the employee can perform the essential functions remotely or not. And so the case has been now remanded, or I'm sorry, the summary judgment motion of the employer was denied, and so this case is headed to trial, or probably settlement, one of the two. The other case on this topic I just want to mention is a little bit more of a positive spin for employers, and that's a Fourth Circuit case that was decided earlier this year. Here, this involved a plaintiff that was an IT specialist at the IRS. And this employee requested multiple accommodations related to her severe depression, anxiety, and cognitive impairment. These requests included, a transfer to a different division, formal training, part-time schedule, ability to work from home, or transfer to a location with a shorter commute. The IRS went through the interactive process with this employee. It granted her some things, but denied others. So it granted her a new assignment, gave her a new direct supervisor, gave her on-the-job training and a 6-month part-time schedule, but said, we can't have you working remotely. All IT system training is done in person. It's a blanket rule we have. We just need to have everyone here doing that training in person. We don't provide exceptions to it. So we can't accommodate that. We looked for other positions closer to home for you that would minimize your commute, but we found no vacancies. And so the plaintiff in this case, the IT specialist, she rejected that accommodation offer by the employer and filed suit. And the court looked and said, no, we actually think that that the employer did offer a reasonable accommodation. And we do believe that she wasn't able to perform the essential function of her job 100% remotely because this formal training is well established by the IRS that it has to be done in person, and there was strong evidence to support that. So this ruling is a reminder on a couple key points when we're dealing with disability accommodations. First, remember, it is a two-way street. The employee doesn't get to choose the accommodation, right? The employer has an obligation to grant a reasonable accommodation that will allow the employee to perform the essential functions of the job. So here the IRS offered a viable alternative, but the employee said, no, it wasn't sufficient. The court said, no, employer, you're in the right on that one. Also, if there's not an open position to transfer somebody to, you don't have to create one, right? So do the search, see if there's something that works, but if not, you don't have to create a new position if no suitable role actually exists. Also, in-person training can be reasonable. And so the other thing to be thinking about too, a lot of cases are finding in-person supervision by managers of subordinates is also reasonable requirement. So something that, again, you want to be thinking about if you are analyzing one of these requests. So again, engage in the interactive process. Make sure that if you can, you're providing that reasonable accommodation. And the final area that I just want to mention briefly on this topic is we are seeing many requests for accommodation now having to do with not whether the employee wants to come to the workplace. They're fine with that part. They just actually can't commute, right? Because of their condition, there's some issue with the travel from the home to the workplace. And there was case law long ago that did find that employers found support in saying no to that, but the EEOC has been very clear recently, and courts have been very clear that the duty to accommodate can extend to the commute as well. So you might end up having to deal with a situation where the employee is granted an accommodation of working remotely because they simply can't commute to work. So something to keep in mind, again, not an immediate no. Go through that interactive process and make sure that you have analyzed, hopefully with counsel, before you reached no.
Can you give us an example of that type of?
Can I? Yeah, so employees who have, let's say, a back issue and they can't sit in the car for long periods of time. Or other types of, physical requirements that require them to be seated, and they're able to be in the workplace, they're able to do the same thing, in that location. They just can't get from point A to point B.
What if they were doing that before?
What if they
So
were?
what if they were working in that position and they were commuting before? And maybe COVID, they didn't have to, and now they have to go back.
Well, they would still need to demonstrate that they're disabled, a qualified person with a disability, right? And then they would have to be able to show that, again, you would go through this interactive process with them to try what is the impact of your condition on your ability to perform the essential functions of your job or ability to commute to the workplace, right? Is it just going to take longer? Would it be possible if we have a later start for you because traffic exacerbates the amount of time that you're sitting in the car? But, if we don't, have you start at 9 a.m., maybe it's a much quicker drive. And so you're able to do that. I've seen cases also where, they had big parking lots, or they had to go from a parking lot and were shuttled into the workers, location of work. And they were able to grant accommodations that got the person the ability to actually drive directly in there. Maybe they couldn't walk from the parking lot to the building, and so they give them a golf cart or some kind of scooter that helps them get assisted device through to their work location. Sure. So just in conclusion, a couple reminders on the disability accommodation. Again, the job descriptions, you gotta make sure that the essential functions are clear from the job description. Make sure that you have the physical requirements in there. When you're thinking about in-person work, don't just think of the day-to-day. Do you have required conferences or trainings, right, that the person has to go to that are in person? Are there, just once a year, but that's a key part of this person's job, right? That needs to be in that job description to demonstrate that it is part of the essential function of the role. You're going to be analyzing whether or not the person can perform the essential function on a fully remote basis, engaging in the interactive process. Don't be afraid to try things and see if they work out, right? And if they don't work out, unlike the court in the Smith case, you want to make sure that you have good evidence to support why it wasn't working, right? But there's great case law that supports that, employer trying it and finding that it doesn't work didn't negatively impact the employer in their duty to provide reasonable accommodation. And then, of course, maintain records of accommodation requests and the rationale. Again, the lawsuit might not be coming for a while after you handle the situation in human resources. As a disability accommodation? Yeah.
Bringing people back, or maybe not as a disability accommodation. Either way. What is the financial duty of the employer that's required?
Well, if you're requiring people, I guess, so this I could spend probably 20 minutes answering this question. Sure. So the question is, if you're requiring employees to come to an in-person location for a purpose, a couple times a year or whatever, what is the financial obligation of the employer associated with that? And then my follow-up question was, well, is this for disability accommodation? Since that's the topic that I'm speaking on, I'll just give my answer on that, and then we can talk about the other part at the happy hour afterwards. But so we're seeing differing case law opinions on this. So there was, I wrote an article about this, which we will link in the, when we send this out, so you can see it. Generally, the position of the courts is that the employer is not having to provide the financial support for the requested accommodation. My recollection is that there was a Fifth Circuit case that found that there was good basis for it. In that situation, the employee wanted to use Uber because they couldn't physically drive, and they wanted the employer to pay for the Uber. And the court said, no, that wasn't a requirement of the employer in that situation. But I think that's an area that's going to be a fact-specific, case-by-case situation. Okay, thanks so much.